Now, recently there's been a bit of a hubbub. You see, flock cameras misidentified a auto reviewer driving a brand new Range Rover as the car being stolen, and police responded and treated him pretty roughly. It was not just smoothed over, is my understanding. Whoever at Flock thought that it was a good idea, whether it be legal or PR, to send their CEO for an interview with the man who was arrested is a fool. In that interview, what I thought was important is this. The Flock CEO, whose name escapes me, he tells the interviewer, the car reviewer, the courts have ruled on this. The courts have ruled that Flock searches don't violate the Fourth Amendment. Well, I guess because he builds cameras and surveillance systems and didn't go to law school, maybe he doesn't understand that the law is fluid, it changes, and it has nuances. This is the year big 2026. In the year big 2018, there was a court decision. It was Carpenter versus the United States. It was a Supreme Court decision. I'll read you a couple of quotes from that case. 2018 now. This is a case again about cell phone data access by law enforcement without a warrant. So it's not exactly on point, but hear the language. The fact that the information is held by a third party does not itself overcome the user's claim to Fourth Amendment protection. We hold that an individual maintains a legitimate expectation of privacy in the record of his physical movements. A person does not surrender all Fourth Amendment protection by venturing into the public sphere. To the contrary, what one seeks to preserve as private, even in an area accessible to the public, may be constitutionally protected. A majority of this court has already recognized that individuals have a reasonable expectation of privacy in the whole of their physical movements. Society's expectation has been that law enforcement agents and others would not, and indeed in the main simply could not, secretly monitor and catalog every single movement of an individual's car for a very long time. I am omitting internal citations. As with GPS information, the time-stamped data provides an intimate window into a person's life, revealing not only his particular movements, but through them his familial, political, professional, religious, and sexual associations. These location records hold for many Americans the quote, privacies of their life. And like GPS monitoring, cell phone tracking is a remarkably easy, cheap, and efficient compared to traditional investigative tools. With the click of a button, the government can access each carrier's deep repository of historical information at practically no expense. The government can now travel back in time to retrace a person's whereabouts, subject only to the retention policies of the carrier. This newfound tracking capability runs against everyone. Unlike with the GPS device in Jones, police need not even know in advance whether they want to follow a particular individual or when. At any rate, the rule the court adopts must account of more sophisticated systems that are already in use or in development. That was back in 2018. Since then, Schmidt versus City of Norfolk is a 2026 case that says the court has already recognized that constitutional analysis is not static. As ALPR networks become denser, retain information longer, or become integrated with additional surveillance technologies, the constitutional balance may change. Judge Davis specifically noted that expanding camera networks and capabilities could eventually tip the analysis towards finding a Fourth Amendment violation. There's another case out of the Fourth Circuit, Leaders of a Beautiful Struggle versus Baltimore Police Department, 2021. When government surveillance becomes comprehensive enough to reveal the whole of a person's physical movements, it becomes a Fourth Amendment search requiring constitutional justification. Commonwealth versus Bell. This is actually a case about Flock. Commonwealth versus Bell. The court granted a motion to suppress Flock ALPR evidence, ruling that Norfolk's 172 camera network constituted a Fourth Amendment search requiring a warrant. The court was particularly concerned about the lack of officer training requirements and unfettered access to 30 days of movement, warning about the potential to create a suspect where one did not otherwise exist. This is again Leaders of a Beautiful Struggle versus Baltimore. The court reasoned that the program enabled deductions about what a person did repeatedly, what he did not do, and what he did ensemble, revealing more about a person than any individual trip viewed in isolation. The court looked at whether surveillance allowed the government to determine where people went, what they did repeatedly, and patterns about their associations. When the Flock CEO says the courts have been clear that his cameras don't violate Fourth Amendment, there's already been a ruling that they have. The law grows. It doesn't grow quickly, but it grows in response to events. For the CEO of Flock to make that statement to a reporter on the record and represent it as true, I see as a material misrepresentation. Either he was perhaps not aware of some of these court rulings, or more likely, as evidenced by the cases against him, he knew and just didn't tell the truth because the truth sounds awful.